Okay.
क्या हुआ?
At this time, those of you who have not seen your attorney or not in contact with your attorney, please call them. You may step out and let them know that you are here waiting on them, okay? And this is the same as well on Zoom. Mr. Ali, I need for you to contact your attorney.
Okay.
Alrighty, let them know that you are here waiting on them.
Judge, but she is in another courtroom right now. I'm not sure when she will get out.
Okay, so find out.
Okay.
Let her know that you're here waiting. The state has just provided me information regarding this, and that is the
And Judge, according to
just
my
need to-
lawyer, she had already applied for the PTI, but she haven't heard anything back from the DAs.
Okay, already. So I just heard from the DA, he just spoke. So I'm giving you instruction to contact your attorney. Let her know that you're here waiting for her and that she needs to talk with the court.
Okay. Thank you. Thank you, Judge.
All right. Thank you so
Judge.
much, sir.
They want us to contact you guys.
And Judge, Miss Sarah Ritchie, the attorney for Mr. Ali, she sent an
Yes.
email to Marina and to myself and ADA Han this morning saying that she had an in-person court setting in Polk County this morning, but that she would log on to Zoom as soon as she was finished with that.
Okay, very good. Thank you very much. ADA Bose says that is helpful. Attorney Zimmerman?
Yes, Judge. I have spoken to the state this morning, ADA Han. I think she is considering a dismissal, but not quite there yet. Needs to contact the CW, the complaining witness on that. And that is an update to the case, Judge. So I believe that we're getting pretty close to a dismissal in this case. We are set already. We have a trial docket setting on the 28th. I believe we should have this case disposed of, quite possibly, prior to that date, Judge.
Okay. So you are set for trial on what date?
The actual trial date, I believe, Judge, is August the 1st. We have a trial docket date of Friday, the 28th of July. I'm sorry, Thursday, the 28th of July.
Hello, you've reached the law office of Ronald D. Zimmerman.
Counsel, do you already have the case setting form for that next date?
No, I don't, Judge. It's just in my notes that we are set for that date.
All righty.
And those notes were from April the 21st.
Okay, let me get you in with the court coordinator to kind of seal that up, okay? Make sure that you guys have a case setting form And we have your clients. We have your client's email address, okay, sir?
Okay, no problem at all, Judge.
Okay, and from there, you're excused, you're and your client, okay?
All right, thank you, Judge.
Except that I have him marked as FTA right now.
Yes, Judge, he did reconfigure his title on his box, and it has both his first name and his last name, Judge.
Okay, all righty, Renee. Is it Barrios?
Yes, ma'am.
Okay. Okay, Attorney White.
Yes, Judge, I have conferred with the ADA, and if I could speak with my client, he's present in the courtroom, Mr. Rich. But if not, I could try to call him over the phone, but if I could get a Zoom workout with him, that'd be helpful.
Yes, sir. We'll go ahead and make that happen for you.
Thank you.
Thank you.
Judge, are you aware that when you go into the breakout rooms and try to come back to the main meeting, you have to actually leave the meeting?
We're wrestling with that issue. I'm not sure
okay.
what's going on with
So you-
that.
so
We
you
think
are
it was
aware.
a Zoom update.
Okay, so you are aware of the issue?
Yes, sir. It has been happening. So we're trying to figure out how to fix that. But thank you so much. If anyone has any ideas, let me know. But I think we're thinking right now that it's a Zoom update
Okay,
issue.
okay.
So thank you for it's annoying at least. So your client is about to get logged in, and I will put Mr. Chauncey in with you.
Okay.
Good morning, Attorney Ritchie.
Good morning, Your Honor.
Yes, I believe that we just may need just a little bit more time in order for the pretrial diversion matter to go through. So let me put you in a breakout room with my court coordinator to give you so that you can reset it
Okay.
for the time that's needed. I would say, I don't know, Mr. Bosis, do you have any idea of how much time that Ms. Ritchie, Attorney Ritchie might need to ask for?
Well, I know that the pretrial diversion people now have everything. They have the agreed order, and he had already applied a long time ago, so it certainly shouldn't take much time from here. But I don't control that part of the process, so I'm not sure. I don't know. I mean, maybe to be on the safe side, just give it a month, but I imagine it would be a lot less time than that.
Okay.
Can you check
Also, Attorney Ritchie, if you have the phone number to the pretrial diversion, you could give him a call and see how much time that you probably may need.
I've emailed and called them many times, and they've always told me it's not going to be much longer. So
Okay.
I don't know how valuable their estimate would be.
Sure. Well, that's as ADA Bosis said, that probably would be sufficient amount of time. You know, you can consider a month so that we can. Okay.
That's fine, Your Honor. Yes, thank you.
Alrighty, let me go ahead and put you in a breakout room and then you can contact your client once that's set up and you can be excused from there, you and your client, okay?
Thank you, Your Honor. I appreciate that.
Thank you much.
Judge.
I'm sorry, 2 seconds.
No, no.
Uh-huh.
I just wanted to remember 3 showed up. That was state team client. She's on Zoom. I had Marina call the attorney. Number.
Oh, yes, okay, thank you. Yeah, she's late.
Oh, okay. Judge Marina would like to be let in.
We're gonna have to find out what's going on
Right,
with all
it's
this.
kicking them out, right?
It is very frustrating. It better be a Zoom thing.
It has to be.
It has to be. What is this? Crazy. The person named as Crystal and Mr. Barber, are you guys from Civil?
Yes, we were assigned by the presiding judge to come here for a 5-minute prove-up.
Already. Ms. Crystal, I'll need your full name. Do you know how to rename yourself? I need for you to display first name and last name, please.
Yes, let me, hold on, I'm not, give me 1 second and I will rename that.
Okay. Attorney Garza?
Yes, ma'am. I'm here on Joe.
Yes, sir.
Case number 686-565. Judge, my client has a felony pending in the 186 and a pre-indictment as well. I'd like to see if I could get a reset until I can dispose of the felony, which may be dispositive of the misdemeanor.
Of course. And they all happen out of the same incident, sir?
I am not sure, but it might have. The criminal trespass might have occurred out of one of those incidences.
Sir, what court are we, are the felonies in? And I take it you're,
In the 186, Judge Moore?
and you're representing him on the felonies?
Yes, Your Honor. I don't normally do the misdemeanors, but I guess I got picked because I represent him in the felony.
Right. Appreciate that, sir. I thank you for going ahead and taking this,
Me
taking
mujer,
that
pues,
on.
venga.
Allow me to put you in the breakout room with the court coordinator, and you and you're excused from there, sir, once you get your felony pending date, okay?
Thank you, Judge.
Hmm. Marina,
Yes, Judge?
yes, can you join Mr. Garza in your breakout room?
Yes.
Yes, sir.
Can we possibly take this up Monday morning, Judge?
We have, is there a reason why we can't hear this at 1?
Yes, sir, the number of commitments is up right now. I was hoping to get this resolved this morning. We found out that we needed to be here yesterday. I'm doing everything I can to that this.
That's kind of cutting it close for a trial. Because we have the folks, we have the jury at, on Tuesday afternoon.
I thought we were coming back Monday morning for trial.
Yeah, well, I set it for Mondays, but
Okay.
I get the juries now, since we're still scheduling the jurors. I get that my schedule is at, on Tuesdays at 12:30,
Oh, okay.
so.
I don't think it would be, I mean, as far as.
I don't, yeah, I'm not too sure this is gonna take that long. I think this discussion is going to probably take longer.
Yeah.
Yeah. It's just that that's the time that I'm sure that I will have a CSR.
Can I go try to find one? I got people all over the building that owe me favors, Judge.
Go get to it.
All right. Let's see what I can do.
All right. Attorney Settle.
Good morning, Judge. Sorry to be late. I was in the 386.
Not a problem. Your cause number.
Oh,
I just,
685797.
yes, ma'am. Anatoly Setsvetsky.
Something like that, Judge.
Setsvetsky. Okay, and did not answer the docket.
Judge, I'm in contact with him. I have sent him the Zoom link. He says he's getting on now, and I'm in contact with him, so I know he's trying to get on. But I'll need to I do need to confer about this with the DA, and I'll also probably need to just pick up the phone and call my client and get him on.
Okay, not a problem. I do apologize. Just let me give everybody a heads up. It seems that when you go to a breakout room, you get kicked out as you try to come back in. So I apologize for that. And please beg your patience for that. So we'll go ahead and get you in there and hang on 2 seconds. Is this your client?
It could be the iPhone that just popped on might be him.
Okay.
Anatoly, is that you? iPhone? You're on mute. I don't know.
I apologize for that.
Is that you?
My name is Dennis Skinner with DS Property Management.
Oh, okay. Judge, I will call him as I go into a breakout room with the DA.
Oh, hang on. Somebody just showed up.
Oh, someone else did?
Yes.
Yeah.
Whoever you are, as far as the iPhone, I need your first name and last name displayed, and you cannot be in a vehicle. Just let you know, sir. So if you're in a vehicle now, you need to get to a quiet place.
And Judge, I do see my client. He
Because I'm
has-
out on that side of the right.
All right. the person at Anatoly, I need your name, first name and last name. Counsel, do you wish for me to go ahead and place you in the breakout room?
With the
ADA?
DA, Judge, if you could, I've already spoken to my client.
Okay. And ADAs, who's conferring?
I'm ready to confer, Judge.
Okay.
How do I change this?
Attorney White?
Yes, Judge, I just want to update the court. Mr. Rich has agreed to accept the state's plea offer, so we need to just get this matter set for a plea.
Yes, sir. Let me go ahead and put you into a breakout room with the court coordinator to get that date set up, sir. And you and your client can be excused from there.
Okay, Mr. Rich is in the courtroom, so Judge, I'm not too sure if he's gonna know when we're done.
We'll go ahead and get him a case setting form and then release him from there, okay?
Okay, Judge, thank you.
Alrighty, and get his, make sure that you provide the court coordinator with the email address. And I just need to find, what's that cause number again, sir?
Judge, that cause number is gonna be 67, he's number 15, Judge, 676-929.
Number 15. Okay, thank you so much. I see it. Okay. When you have the docket and you're able to number it, it goes so much quicker.
Yeah, I can see that efficiency.
Okay, Mr. Rich? All right, so what's gonna happen is you just sit there, your attorney is getting a date. My court coordinator will come out and talk to you, okay, and give you a form. All right, thank you. Rochelle Cummings, are you here from civil? Are you on a civil
yeah.
matter?
No, ma'am, I believe it is eviction.
Okay,
It's civil.
alrighty.
Oh, civil.
Hi. And you're Dennis Skinner?
Yes, ma'am.
Civil, okay, and Tai Chu, you are here on a civil matter?
I'm here for the interpreter Vietnamese. The case number is 2022 CV00065.
Okay. Alrighty, thank you, sir. I'm going to go ahead and send you all an invitation to a breakout room, and I'll join you very shortly, okay?
All right.
Thank you.
Okay, so this is a situation, Attorney Chumley, and any other attorneys that are waiting for to take a plea. I do have a court reporter at 1 o'clock. Attorney Chumley, you're telling me, you've told me already that's not gonna work for you this afternoon. So that's not a problem. That's not a problem, sir. I'm also, as Attorney Strickland, he says he's going to go find a court reporter. So he's hunting around for that. And I'm also hunting around to see if we can get a court reporter. Attorney Chumley, please let me know for how long you can wait till, and then we'll get reset, or if you wish to go ahead and get a reset now, we can go ahead and do that as well.
Well, and I'm sorry, Ms. Torres, I know you've taking off from work, but if there's any way we do it next week, it would be very, I've got a sick daughter and I've got to take care of a couple of her babies and I need to be there, between 11:30 and noon, and I just don't want to risk it. So if there's any way I could maybe set it up for next week.
Did you want to talk with your client first?
No,
and
she's,
get an idea?
she's nodding with me here. She's okay with it.
Okay, all righty. Let me go
okay.
ahead and put you in a breakout room with the court coordinator. And sir, she'll need your client's email address, and then
Okay.
she'll be able to go ahead and you and your client are excused once you go ahead and get it reset. Okay, sir?
Sure appreciate your honor. I'll see you next week or whenever, okay?
Yeah, I apologize.
No, that's all right.
We're
Hey.
doing- the shortage is getting to us.
Yeah, it's the way it is these days. We're
Yes, sir.
okay. All right, thank you.
Thank you for your understanding. Have a
Okay.
great weekend, and please, I hope that your daughter feels better soon, okay? Attorney Pena, you need to unmute, sir.
Yes, Your Honor. How are you?
Good, good. How are you doing, sir?
Very well, thank you.
Good, sir.
I'm here with the plaintiff, Irma Ibarra.
Okay. Sir, I will go ahead and I'm going to put you in a breakout room and then I'm going to join you, okay?
Thank you, Judge.
Who's on the other side with you?
Her name is Castillo, Adamina Castillo,
Okay,
or Andrea Castillo.
alrighty. I don't see the person. Okay. Mr. Matthew Marolis?
Yes, sir. Yes, ma'am. I apologize, Your Honor.
Okay. If you could go ahead and just kind of remove that right there, that would be helpful.
Remove.
Move your hand. Yeah, that's it.
I'm sorry.
So, sir, are you here for a case, a civil case?
The one you just talked with Mr. Pena and Andrea.
Right.
I own the trailer that they're staying in.
Okay, not a problem, sir. I will be right with you. Okay, I'm gonna put you in that breakout room.
Okay, thank you.
Okay. Matthew.
Yes, ma'am.
Go ahead and join that breakout room. And who is Moto G Power with the hand raised, the Zoom hand raised? Moto G Power, you have your Zoom hand raised. Attorney Perez, good morning.
Good morning, Your Honor. I'm here on George Essenberg. He's not, I think he was recalled from probably a couple weeks ago. I just need to be put into a breakout room with one of the ADAs.
Okay. What's the case number, ma'am?
The case number is, let me pull that up again. Hold on. Six, I just had it a second ago.
77695.
Thank you.
And what's the name?
George Essenberg.
Essenberg, okay. Oh, okay. Which number is it? 16? Okay.
Yes.
Okay. Counsel, thank you very much for being here. And he did not answer the docket, just so that you know.
And Your Honor, I did clarify that with your coordinator. The last time we appeared in court, you had instructed the defense attorneys that their clients did not need to be present for the next setting, that it would only be a pretrial conference between the defense attorneys and the prosecutors. And so he was excused.
Well, the thing is he set for pretrial conference hearing today? Let me double check, okay?
Yes.
Attorney Perez,
Yes, Your Honor.
right. I see he has had a few settings. I'm going to put you in with the court coordinator at this time because it appears that he was set for pretrial conference hearing on the 30th of June, 2022. That's what I'm
That's a
seeing. So,
recall. It's a recall date. So his original appearance, the last time I appeared with him in person, or I'm sorry, via Zoom, was February 22nd. On that date, we reset it to June 30th. But at that point in time, I did not know in February that I needed to be out of town. I had a vacation letter on file with the clerk for that date. So it was recalled to today. But in February, when we were reset, you specified to defense as well as the state that the defendant did not need to be present, which is why he was not here on the 30th nor on today.
right. And I'm going to, I just wanted to go ahead and make sure of that. I do appreciate that recitation. So let me just make sure of what is noted in the by the court coordinator, because I don't have the file here with me. So make sure that we're on track with that, okay? We're on the same track.
Okay.
And then I'll put you in with the ADAs, okay, ma'am?
Okay.
Thank you so much.
Thank you.
Attorney Settle.
Yes, Judge, I have conferred. Judge, this is a DWLI case and it's a first setting. So we're asking for some time for my client to get his license back. The ADA said she would dismiss if he's able to do that.
Okay, so we have what appears to be a conditional dismissal.
Correct.
Program, she's going to set that up. Let me go ahead and get that on record, but your client needs to have video. He hasn't appeared before the court. I have not recognized him and he only has his first name. So do you want to go ahead from, he just needs his name and first name, last name, so I can be able to at least recognize him.
Okay.
Mhm. Attorney George. Attorney George.
Yes, sir.
Good morning, sir. If I could, would you please, could I put you in a breakout room with the ADAs to find out where your paperwork is for the plea? I just checked and it's not there.
Uh,
I don't have
my
it.
client should have it. I'll check with her.
Okay, alrighty, thank you. Okay, so now the person at Moto G Power 2022.
Yes, I'm Andrea Castillo. I was supposed to be in the breakout room with Irma Ibarra and Matt Margolis.
Sure. As soon as you go ahead and rename yourself to put your name and not your device's
Oh,
name.
okay.
Yes, if you would do that kindly, I'll go ahead and be able to.
Okay, let me do it. Hold on one second, please.
Alrighty.
Thank you.
Attorney Settle, it seemed like your client is not Zoom savvy.
Yes, Judge, I just spoke to him and told him to put his full name. There he is on video.
Yes, ma'am.
But you need to put your last name on for your name as well, first and last.
All right, let me do this. In the chat?
No, see where it says your first name, you need to add your last name.
I'm going to also put him in with the deputy, okay?
Okay.
Yes, Ms. Torres, go ahead and call your attorney.
And I'm able to go, ma'am?
Call your attorney. I believe that you should be. I believe
Okay,
the
thank you.
attorney is Mr. Chumley.
Yes, ma'am.
Right. Just make sure that you're all set up and you should not leave unless you have a case setting form. Okay?
Okay,
Alrighty, so call your attorney and see where that's at.
okay.
Yes, yes. I mean, he doesn't know how to do it any other way. Okay, and listen up, your hat, you have to remove your hat. You have to have that phone steady, sitting down on the table. Yes. That's.
iPhone, you need to go ahead and rename yourself. I'm putting you back in that breakout room and I'm joining you now. Hey, sir, how you doing? Okay, if you don't mind, just give me a second. Okay, thank you.
Joseph, are you on? Is the coordinator on here? This is a court reporter. I was told to log in.
Armenia, this is Joseph Strickland. We're just waiting on the judge.
Oh, okay. All right. I didn't know what was happening.
I'm sorry to interrupt, I just don't want to do that.
Is that Ermina? You,
Yes, Erminia Oviedo. I'm ready, Judge.
okay, thank you. Okay. Miss you
Oviedo.
Oviedo, Oviedo. Thank you. I appreciate you being here. Let me take up just a short matter and then I will be with you as, okay? And so we don't need the, so let's go ahead and get an electronic record. State, are you ready to go ahead and get an electronic record for federal case? Okay.
Yes.
On cause number, Anatoly, on cause number 685-797, court is going to call that cause number 685-797, State of Texas versus Anatoly Setesky. Parties, please approach and identify who's before the court, starting with the state.
Linghan Martinez for the state.
Elizabeth Settle for the defense, Judge.
And are you Anatoly Setesky?
Yes, Your Honor.
Okay, and I do apologize on the pronunciation or the killing of your name. And we are here because the case, counsel, you're telling me that the state has offered a conditional dismissal on this. State, proceed to tell me what the condition is, please.
Judge, we are asking that the defendant provide the state proof of a valid driver's license, proof of financial responsibility, and current registration inspection for the vehicle that he is driving. Further, the state is not opposed to allowing the defendant up to 6 months to provide proof of these conditions.
That's a valid driver's license, financial responsibility, and registration.
Yes, Your Honor.
Okay, thank you. Defense?
Yes, Judge, that is what our understanding is, with the exception that I have spoken to my client. he no longer has a vehicle, so the registration is not something he'd be able to obtain, but the other two, he understands it's his obligation to obtain. But if he has any vehicle, he understands that needs to have a valid registration.
Okay, with regard to, there was a vehicle involved at the one time, correct?
Correct, it was his vehicle,
Okay,
and yeah, he sold it.
okay, I'll need to go ahead and get an affidavit on that. That's identifies the vehicle, year, make, model, color, license plate number, and last 6 digits of the VIN number, and what has happened to that vehicle with a third-party verification. For that, and then as far as financial responsibility and valid driver's license, what day are you looking to go ahead and reset that so those items can be taken care of? Do you have a date?
Could we do October 21st, Your Honor?
Why do we need that long? It's a conditional dismissal.
Just in order to get all the things he needs to obtain, the insurance, obtain the license back, and that can sometimes take a while. There are fees involved with that as well. Whatever
Is
the
he
court,
employed?
Judge, I'm not sure. Whatever the court deems reasonable or appropriate.
Counsel?
Yes, Your Honor.
Give me 2 seconds. Sure. Counsel, please understand this and make sure that you import to your, convey to your client this that I'm stating. On the 21st of October, 2020, if these requirements are not completed, he will need to plea on that date. Okay? The state has been generous in providing this opportunity for dismissal. If he does not take advantage of it and get this matter dismissed, he will need to plea on that particular date, on the 21st of October, 2022, I'm sorry.
Yes, Your Honor.
Okay, and make sure that any proof of completed requirements are e-filed with the court
Yes, Your
as
Honor.
well, okay? Counsel, does the court coordinator have the email address for the defendant?
I did email that to her, yes, Judge, on 6/16.
Alrighty, thank you very much. You and your client, is there anything further on this matter, State?
Nothing further, Your Honor.
Anything further, counsel, the defense?
No, Your Honor.
Alrighty, thank you. You and your client are excused. I appreciate your time, ma'am.
Thank you, Judge.
Okay, let us get on record. State, if you could pull up cause number 662-936, 662-936.
Yes, I have that one ready to go.
Counsel, do you have the microphone?
I do, Your Honor.
All right. If you would just either put it here or you want to sit down, whichever one you want to do, sir.
This works fine. Thank you, Your Honor.
All right, thank you. Let's get on record on cause number 662-936, State of Texas versus Daniel Raymond McDonald. And this is the case that you'll be taking record for, Ms. Oviedo? Thank you.
Yes, Judge, I'm on here.
Thank you. Parties, please approach and identify who is before the court, starting with the state.
Brett Bose is here for the state.
And Joseph Strickland here from Mr. McDonald.
And are you Daniel Raymond McDonald?
Yes, I am here.
Let the record reflect that the defendant is here with is in this court session with his attorney, and we are operating on a hybrid mode. The attorney of record, Joseph Strickland, is in the courtroom while the state and the defendant and the court reporter are on Zoom. We're here regarding a discovery matter. Is that correct?
Yes, Your Honor.
Alrighty, defense, you requested this hearing, proceed.
Yes, Your Honor. We discussed briefly at the call docket yesterday at our pretrial conference hearing back on February 17th. The state agreed, or the court ordered, or both, to provide a list of witnesses ahead of our upcoming trial date by June 22nd. That did not happen, Judge. And so we're here. The state announced ready for trial yesterday, Judge. If they are, then that is fine with me, Judge. I just, if they wish to proceed to trial, we're going to ask that they be precluded from calling any witnesses that they did not provide proper notice of, Judge. And we did not receive proper notice of anyone. And so we would ask that the state be precluded from calling any witnesses at this trial if we are to proceed.
Let me ask you, did you request, or how did the state understand that you needed witnesses?
At the pretrial PTC hearing, Judge, you asked if we were to accept constructive notice of the state's file. I said, no, we do not, that we wanted a list of witnesses to be provided. We agreed on June 22nd, which is actually inside of 20 days. I miscounted that day, I guess. I meant to give myself 20 days and I didn't. So it was actually a little extra time, Judge. And in the 4+ months between the PTC hearing and that deadline, we received no notice, which is fine, Judge. If the state does not intend to call witnesses, that's fine. They announced ready for trial yesterday. So I don't know if that's the plan, then that plan works for me, Judge.
Okay. Did you file a motion?
We also filed a request, Your Honor, yes, on June 15th, 2021. I think it's pretty much the only motion we really filed in this case, aside from a notice of appearance, Judge. It's a request under 3914, which under 3914, if we request notice, we need to get it, and we didn't get it.
State.
Yes, Judge. So firstly, let me acknowledge that, yes, it's correct that we did not turn over a list by June 22nd. I'm not gonna hide from that fact or run away from it. It was accidental. It was not an intentional avoidance of that deadline. I forgot about the fact that we were supposed to create a witness list and turn it over on that date. And so I do apologize to the court for that. However, I do not believe that that is the end all be all of this issue, because as the court of defense were just kind of discussing a moment ago, what the defense filed is a request. I have it pulled up through file 360. It was titled Notice of Formal Request for Discovery and Disclosure. It was not a motion. There was no hearing held nor any order from the court regarding discovery. It was just a request. And a party can put anything they want into a request, but without a hearing where both parties have an opportunity to make arguments and to have their side heard, a request is only enforceable as far as what the law says is enforceable. And so this request under 3914, as defense counsel pointed out, in 3914, the exact wording of the statute is that on a party's request made not later than the 30th day before the date that jury selection in the trial is scheduled to begin, or in a trial without a jury, the presentation of evidence is scheduled to begin, the party receiving the request shall disclose to the requesting party the name and address of each person the disclosing party may use at trial to present evidence under rules 702, 703, and 705. Those three rules are all related to the testimony of expert witnesses and the scientific bases for their testimony. The Article 3914 is noticeably silent on the necessity of turning over other witnesses upon a simple request. And that's because there is no requirement in 3914 that upon a simple request, every single witness be turned over. The requirement is that expert witnesses must be provided to the defense. So legally speaking, while the defense certainly has an argument that our expert witness, who in this case would be our breath test expert, should be precluded from testifying, our other witnesses who are San Antonio police officers, there's also those other 3 witnesses should not be precluded from testifying, and there's no basis in 3914 to preclude them from testifying. Further, I was looking over the file, which, as the court is aware, the DA's office has an open file policy. Everything in our file has been available to the defense since basically the inception of this case. And in that file, I counted the name and badge number of the primary investigating officer appears 13 different times. The name and badge number of the secondary officer appears 10 times. And there's a third officer whose name and badge number appears 4 times. So those 3 witnesses, their names are literally covering the documents that defense has had in their possession for over a year. And while I understand they wanted a witness list as well, there cannot be a good faith argument that they did not have notice and that those witnesses were not disclosed, because their names are all over the documents that we've provided to them a long time ago. And that's the point of these rules, is fairness and justice to the defense, and that there's no surprise, that they have an opportunity to prepare for these witnesses and respond to them. And so that's not an issue here. There's no issue of surprise or of unfairness to the defense, because they're fully aware of all of the people who we would and could call as witnesses in this case. And so, Judge, really the only person who might be precluded from testifying would be our breath test expert. Other than that, there's no reason to preclude any witnesses from testifying in this case.
That 39.14, that section that you cited and read into record, what was that?
That's 3914B, Your Honor.
B as in Bravo?
Yes, B as in Bravo.
Thank you. Defense?
And Judge, and I mentioned 3914 and I mentioned our request because you asked me. That's not really what we're talking about, though. What we're talking about is, what are we doing, Judge, when we have a PTC setting in your court? What are we doing, and does any of that stuff matter? I think it matters, and I think if you said during that PTC hearing that I needed to do something, I think that I need to do it. And at that PTC hearing, my good faith argument that I didn't have constructive notice is that you asked me. You said, do you accept constructive notice of the witnesses in the file? And I said, no, Judge, I do not. I do not. I said that 5 months ago. Okay? I said it 5 months ago. I do not. I want a witness list and I need a witness list. And you said, state, you will provide a witness list. And they did not do it. And that's not something that's not a request I filed, Judge. That is an order that you made. Okay. And so that, I think, has to matter. That if the judge in a court says that we're going to do something a certain way, that has to mean something. And I think it does. And what I think it means here is that if we didn't do it, that's a problem. And it's not my problem. It's the problem of the party that didn't do what they were supposed to do. And in this case, that's the state. I'm not mad at him. I don't think Mr. Bosis did this to be mean or to trick me or anything. I just think it happened, but it happened, Judge. And I'm sure he's right. I'm sure the names of these witnesses are all over their file, Judge. And it should have been real easy for them to find them in the 4 months between the PTC hearing and the deadline to make a witness list. And they didn't do it, Judge. And so if they're announcing ready for trial after just blowing through the deadline that you set for them to turn this over, Judge, I don't know how they announce ready unless that's what they mean, is that going by your rules that you set at the PTC hearing that we would have notice of witnesses by a certain day. And if we don't have them by that day, then we don't have notice of them, then that's it. And we didn't get them. We got notice of 0 witnesses and we came here yesterday and the state did not ask for a continuance, Judge, and they still haven't asked for a continuance to fix this. They said they're ready. And so if they're ready by the rules that we set at PTC, then let's do it, Judge. Let's do it right now.
State.
Judge, I have to take issue and disagree with defense's characterization of what happened at PTC. He said that at PTC there was an order from the court. And I certainly agree with him that what happens on at PTC matters, and that we're not just saying things that are meaningless. That's certainly not my argument. But there's a difference between having a discussion on record and an order from the court, which involves, generally speaking, some kind of signed document ordering something, which is not the case. And I've been through countless PTCs in this court. I know very well how they work. And so I know and I remember that Your Honor always asks the defense, will you rely on the state's file and police report? Will you file a motion, or will you have the state read the witnesses into record? And he's right that he didn't agree verbally to rely on our file and police report. He said that they would file a motion, or in fact that they already had. Now, minor quibble, it wasn't a motion, as we talked about, it was a request, because a motion would have involved a hearing in front of the court. They had filed a request, and then the court, after it asked the defense how they want witnesses done, they then ask if defense says they'll file a motion or that they already have, the court then asks the state, when will you respond? And we give a date. And I already acknowledged that we gave a date and that we missed it. And that is on us. But there was no court order. There just wasn't. There was no court order specifying you must turn over a witness list with every single witness, or else they will be precluded from testifying. You ask the state, when will we respond to what the defense has filed? And what the defense had filed was a request. And as I just pointed out to the court, a request made under 3914B relates to expert witnesses. It says so there in the plain text of the statute. If they wanted a witness list that goes beyond what is spelled out in 3914, we would have needed to have a hearing and an order on that issue. And so, yes, I'm acknowledging that we failed to comply with the deadline. And that's why I've said they have a good argument that our expert witness should be precluded from testifying. But our other witnesses who would be offering opinion testimony, they should not be precluded from testifying. 3914 doesn't say they need to be precluded from testifying. And Your Honor didn't give the state an order that we needed to turn them over, or else they would be precluded from testifying.
Just a little more, Judge. We had a hearing about this. It was called the PTC hearing. And if you judge, if you say something in this courtroom, if you order me to walk over here and sit down right now, That's you ordering me to do that, and I'm gonna do it. I'm not gonna ask you for something in writing that you sign. I'm gonna do what you said. Because when you're on that bench and you say something, that is an order from this court. It doesn't need to be in writing. It doesn't need to be signed. You said it, it's on the record. That's all there is to it, Judge.
State, anything further?
The only thing one last thing I'll add is just to reiterate that all of the witnesses who the state would call at trial are their names, badge numbers. They're in documents that defense has had possession of for a long time. So both parties know who the witnesses are, and everyone's had ample opportunity to prepare for those witnesses to testify. There's no unfairness to anybody for them to testify. And that's all.
State defense, go ahead and approach with the state. State, are you aware that on the judge's notes for the pretrial conference hearings, that I signed each one of them?
No, I wasn't aware of that, Judge.
But you're aware that in the judge's notes are filed in the court file and available for both state and defense. The court file is available for both the defense and the state to look at. It is file stamped, it's scanned, it is made part of the court file, and it is signed.
Yes, I can see it, Judge.
And in this, I believe that on the 17th of February, 2022, Attorney Strickland, you are the one who appeared on this matter. The state was represented by Evan Myers at the time, and the defendant, and the cause number is clearly stated. The agreements with trial dates and announcement dates, an interpreter, whether an interpreter is needed, that's clearly stated. The court does give three options for witnesses, regarding witnesses, whether the defense will rely on the state's file and police reports, file a motion, a request, and the date that or have the witnesses read on record. In this case, the defense stated that they will file a motion or had requests filed on record on the 16th of June, 2021, and the state stated they will respond on the 22nd of June, 2022, with the trial date being set for the 11th of July, 2022, and the trial announcement was yesterday, the 7th of July, 2022. Also, the court does admonish the parties to exercise due diligence to ensure that discovery does not impede the execution of trial on the set date. Witness list is a matter of discovery. Both the state and the defense acknowledged the court's admonitions, and the court did sign this document. and it was filed, and the date stamped was the 18th of February 2022, and has been in the court's file since then, available to both the defense and the state. With that information, State, do you have anything further on this matter at this time?
Yes, Judge, I actually do have something further. There was a decision from, well, originally it was from the Court of Appeals in Austin. However, the case was then, there was a petition to the Court of Criminal Appeals, and the Court of Criminal Appeals upheld that decision by the Court of Appeals in Austin, Texas. And that's the case of Osborne v. State, and I can provide a copy of this case to defense and to the court. But in that case, they specifically held that 3914 and a request made by defense under 3914 entitles them to disclosure of expert witnesses, but that it does not apply to all lay witnesses. And so a simple request is not enough to then, a simple request, if the state doesn't turn over all of its lay witnesses, they held that that doesn't mean that those witnesses need to be prevented from testifying. Because a request under 3914 is just applies to expert witnesses, because that's what it says in the plain text. So it's a decision from the Court of Appeals in Austin that was upheld by the CCA. And so we would just ask the court in this case to stand by that by all means, if the court feels it's necessary to preclude our expert witness from testifying, then okay. But our other witnesses, there's no legal basis for prohibiting them from testifying.
And the site for that?
That is 92 Southwest 3D 531. And like I said, I'll provide those to defense and to the court. I can email it to everyone.
Please do.
Again, Judge, we're not really talking about 3914. We're talking about discovery being ordered by this court and not being complied with. It's just two different things.
State, anything further on this matter?
Judge, I believe, and I've made the argument to the court that while we did not comply with the deadline established, it would be a different case if there was a court order telling us to disclose all witnesses, as it was, the court asked when we would reply to what the defense filed. And what the defense filed was a request. So we asked the court to follow the law and allow our witnesses to testify.
And Judge, I'll just read line 14 of our request. It says a complete list, including the name, address, and phone number of any witness the state has contacted or consulted with at any time during the pendency of this matter, but does not intend to call at any phase of this matter, including expert witnesses. I have nothing else to say, Judge.
So you're saying that your request was a little bit more detailed than just the names and the badge numbers?
It just asked for everybody, Judge.
Um, I will take this matter into consideration at this time. If you have nothing further, counsel,
Nothing further from the defense, Judge.
and state anything further?
No, Your Honor, nothing further from the state.
All righty. All righty. I will get back to you guys by Monday.
Okay, thank you, Your Honor.
Okay, state?
Maybe-
Yes, that sounds good, Judge.
All righty. So on Monday, I will respond to this matter.
Thank you, Your Honor.
Thank you.
May Mr. McDonald log off Zoom?
Yes.
Thank you, Judge. Thank you, Your Honor.
Ms. Oviedo,
Yes.
let me go ahead and get a draft of that transcript, please, as soon as possible.
Noted.
Thank you.
Thank you.
Okay. Oh, thank you. Okay, Mr. Tao is still here. Mr. Tao, and you're saying that he's supposed to be in County Court 3?
Yes, ma'am.
Do you have a Zoom number or Zoom link for him?
I don't. He can call Miss Lydia in County Court 10 and she can get him to rebook.
Do you have that? Okay,
It's
here's his phone number. Can you call him and instruct him, please?
okay, yes, ma'am.
He's right there.
Okay.
Thank you. Mr. Chow, you're going to be getting a phone call from the clerk to tell you where to be, okay?
Okay, okay,
All right,
thanks, Your
thank you.
Honor.
All right, thank you.
I'll give him a call.
Okay, thank you.
Thank you so much.
And Judge, this is ADA Han Martinez. May I be excused? I have a family matter that I'm attending to this afternoon, and I need to get on my way.
Alrighty, we have plenty, we'll have a court reporter very shortly this afternoon, but Attorney ADA Bosis, you'll be able to handle the afternoon docket? Afternoon matters?
Yes, Judge, I will be here to handle all the pleas that need to happen this afternoon.
Awesome. I hope everything goes well. ADA Han Martinez, have a great weekend, okay?
Thank you, and I will try and get in ASAP just to make sure, Mr. Bosis, that I can assist Mr. Bosis if court is still in session.
Okay. Alrighty, thank you.
Thank you, Judge. Thank you, Mr. Bosis.
Yes, please. You need to press that button.
Yes, sir. Just press.
This?
Yes, and it'll pick up your voice.
Okay.
There you go.
I was delayed. My name is Keith Engelke. I'm representing Jean Regari, and he's set for a plea today. Mr. Regari informed me he did not want to plead his case. He wants a trial. I've also filed a motion to withdraw the case.
Do you have the file, sir? Because
Case number is 675-390.
No, do you have the file and your motion to withdraw the file? The court file. Can you grab the court
I don't have
file?
a court file.
Yeah, yes, sir. It should be available in the chambers.
Judge, I'll run it to you. I have it with me.
Deputy, before I forget. You're working on it, but this is the incident number, so if it comes through.
Oh, no, we got temporary ones, that's what I was working
The
with.
external?
The external, and we tested it in a breakout room and it's working. Though I was trying to see if you could hear me on the regular. He's still gonna order the inside. And so I'm on it.
Okay,
Yes,
right,
yes.
but that's the
Okay.
face number.
And that was all in there, baby.
Alrighty, Alrighty, Mr. Rugari, please approach. Okay. You can be over there, sir. We need to be able to hear your,
Did you want him up here, Judge?
yes, please. I need to be able to, if you would, counsel,
Right here, sir. Just,
on that side. The different-
sorry. Keep your hands behind your back.
counsel. With Zoom, we have kind of forgotten all the procedures. So, counsel, we're going to make an electronic record of this at this time. And so let's call, let me call for record purposes. Cause number 675-390, State of Texas versus Jean or Jean? Okay, Rugari. Parties, please approach and identify who is before the court. This is a matter of a motion to withdraw as counsel. The state of Texas is noticed, so starting with the state.
Yes, Judge. Brett Bosis for the state is here.
Okay,
Keith Igolke is a movement.
and are you Jean Jean Rugari?
Yes.
Okay, you need to speak up so that we can hear you on record. Are you Jean Rugari?
Yes.
Okay, alrighty, sir. Sir, your counsel, you are the movement in this case. It's your motion. Please proceed.
My client and I are just unable to agree on strategy. He has received an offer from the state, which I've recommended that he accept. He does not want to do that. He wants to have a trial on the matter.
Okay. And a note here, the court file, and we had a pretrial conference hearing on this matter on the 10th of March, 2022. I usually excuse defendants from the pretrial conference hearing, although sometimes I do mark if the defendant is present or not. But in this particular case, I did not mark whether Mr. Rugari was present. Do you recall, was he present during that particular hearing?
I believe he was, but that was just some time back.
Sure. And in that, I noted that an offer was conveyed by the state, and you acknowledged that an offer was conveyed by the state. It was, I noted here that it was a jail court offer.
Yes, it was.
And this had been conveyed to Mr. Rugari?
I believe so.
Okay, and at the time that he agreed to go ahead and comply, follow that offer, he accepted that offer?
I believe I relayed the offer to him, Mr. Rugari. I don't believe that he accepted that offer. Mr. Rugari is not a United States citizen, so we had to have additional advice regarding his immigration status as to whether or not to accept that offer.
I note that here as well, that immigration attorney appointment, he had an immigration attorney appointment the next day on the 11th of March, 2022. Yeah, and so we're here for, as far as the plea is concerned, and you're stating that there's a opportunity that he may not have accepted that offer?
I'm not sure that he did. The problem that I had was whether or not a guilty verdict would affect his immigration status. I didn't know. I asked Mr. Regarding to speak with his immigration counsel. He's advised me his immigration counsel told him that that would not be an issue for him because of his status. He's a lawful permanent resident.
Mr. Ruggiero, do you have any objections to Mr. Engelke withdrawing from your case?
By myself, I don't have any problem with this gentleman here, but I have problem with my case. And he sent me to talk to the immigration lawyer. I spoke to him. I talked to him back, give him his phone number and email address. I think he called him and he confirmed that I don't have any issue with immigration. And then on 6 July this week, he sent me an email, told me that we have a deal. I say, so I can take that deal, but I'm worried about this case. Whoever did it, he's gonna do it again. You need to come here to confirm that I did. If the court find I'm guilty, I have to get punished. Even if body injury, if he went to hospital, I need to pay that bill. I keep talking to him about this case. It's very easy. I have
Okay.
5 points.
All right. I don't need to go into the facts of the case, sir. So you don't have an issue with Mr. Engelke withdrawing from the case or staying on the case? Do you object to him withdrawing from the case?
I didn't ask him. He sent me email. He said that I will not be your defend attorney no more. I have email here. And I didn't respond. I say, okay. I send email, say, okay, I will be to court Friday morning at 9 a.m. That's it. So my issue now, I can't take the deal, but now I have 4 false accusations.
Sir?
Yes.
Again, I'm just worried about, as far as the relationship here, whether I need to sever the relationship, cut the relationship between you and Mr. Engelke, or do I go ahead and say, hey, listen, he's still representing you or not?
I think he can't keep defending me because we don't understand. That's only the point. I don't have a problem with him, but we don't understand at all. Thank you.
So you feel that you have no objection to him getting off your case?
No.
You have no objection to that?
No.
Okay.
I believe he would like you to appoint someone else because he's still indigent.
So let me understand this. Counsel, you're saying that he wants trial and you do not want to take the matter to trial? That's the reason?
We received an offer from the state that I believe he should accept. And just based upon my experience, I think I think it's better it's in his interest to do that. He does not agree.
Because he's asking for a trial, correct?
That's right.
But sir, you're capable of taking the matter to trial if that's what he wants.
It's been a while, but I just don't think that the risk of a trial, the outcome of the trial would be in his interest. He disagrees. I understand it's his right, but I just don't agree with the strategy. We have a disagreement on the strategy of the case.
Mr. Rugari, you understand that that's what you're asking for, is to go to trial.
Yes, ma'am.
Okay, Mr. Rugari, what we'll do is we'll go ahead and get another attorney appointed to you. You're indicating that he's still indigent? Right? Yeah, we can go ahead and reapply. It's been a while, but we'll go ahead and you were appointed. And then we will go ahead and get you an attorney who will take the matter to trial for you, okay?
Thank you so much.
All righty, counsel?
I assume that means my motion is granted.
Yes, yeah, your motion is granted, sir. I've signed it.
Thank you, Judge.
Yes, sir.
They would be excused.
Yes, yes, counsel, you can be. And Mr. Regari, if you will just go ahead and wait, we'll get you squared away, okay? Thank you, counsel.
Thank you, Judge.
Always. State.
Yes, Your Honor.
Just, we're off record on the matter.
Okay.
Mr. George, Attorney George.
Yes, Your Honor.
Believe. Yes, driving while intoxicated. Let's see, have we gotten that? 685-832, okay. Council, we've gotten that, and please, we'll go ahead, and I'm going to break now. I do realize that you've been here. I got the paperwork. I will have a court reporter by 1 o'clock, so we'll be able to go ahead and take this plea at that time, okay, sir?
Yes, Your Honor.
Is 1 o'clock okay for you, or 1:30 be better?
1 o'clock works for me, Judge.
Alrighty, thank you. If we can do 1:30, would that be okay for you, sir?
It's whatever the court wants to do, Judge. I'm fine either way.
Thank you so much. I appreciate your patience with that. We'll see you at 1:30, sir. Have a good lunch.
Yes, sir. Thank you.
And your client is Jasmine Barajas?
Yes, sir.
Alrighty, thank you. Okay, you can go to lunch and be back here at 1:30, okay? Thank you.
Thank you, Judge.
Alrighty, counsel, your excuse, thanks. Anna Marie Garcia? Let me look here.
Can you hear me, Your Honor? Hello? Can you hear me?
Yes, ma'am. I'm trying to find who your attorney is.
Monica Guerrero.
Oh, okay. Alrighty. We're in contact with your attorney. So
Yes.
we'll come back at 1:30.
Yes, ma'am.
We'll see if your attorneys can get back here for you. He was
Yes.
here earlier for you.
Mhm.
You were late. So he
No,
had
it's
to
a boy,
attend to
it's a
other
girl,
business.
Monica Guerrero.
Okay. So the attorney should be back for you, okay? We'll tell him to come back at 1:30. So be
Okay.
back here, be back on at 1:30, okay?
Yes, ma'am. I apologize, Your Honor. My daughter has COVID and I'm stuck with my 7-month-old granddaughter and they just moved in from Kansas. So I'm trying to juggle, but I don't want to miss court at all.
Thank you. I appreciate that very much.
Yes, ma'am. Thank you very much for your patience.
Okay, see you at 1:30.
Yes, ma'am.
Counsel? Thank you. Oh, there you are. Okay, I was just gonna say, you're gonna have to come back at 1:30. And this is a DWI case. I
Yes.
have a court reporter at 1:30. We have to put it on 1:30, so see you at 1:30.
Pardon?
See you at 1:30
1:30.
already?
Oh, okay, Your Honor. Yeah. What happened to your court reporter?
I don't have one, so I've been borrowing from folks.
Was
and-
that right?
Right, and I have to get one.
Okay,
And I got one, it's coming in at 1:30.
okay. At 1:30 then?
Yes, sir.
Okay, just nice
Thank
seeing you.
you. I think we've got the paperwork and everything on.
Yeah, everything's ready to go.
Okay.
You're ready to go. You gotta,
Ms. Jennings, we are now, the court is in recess till 1:30.
Okay, thank you.
Alrighty. Thank you. Oh, Ms. Jennings, I need the information of Solis. Can you Skype that or email that to me, please?
What was that? I'm sorry.
I sent you an email. You may have responded to it already. I'll go ahead and Skype you, okay? Samantha Solis.
Oh, yes, I did respond. Yes, the officer has been out, so yes. So let me see if she's in now.
Okay. Okay.
Oh, she's probably at lunch now. But yeah, I did. Yes, I did respond.